Welcome to the law offices of Chris M. Ingram's Immigration News Show. Today we ask, your SD was just denied with 0 explanations, so are you looking at a 5-minute fix or a permanent closed door? We would like to thank attorney Chris M. Ingram and staff at the law offices of Chris M. Ingram for their hard work in preparing the research for this show, which draws on a wide variety of news sources from both sides of the aisle, providing a balanced view. Attorney Ingram is also a vocal advocate for the rights and protection of immigration applicants, although our coverage is designed to be nonpartisan. Please don't forget to like, follow, and subscribe to our channel. We are also on Spotify, YouTube, LinkedIn, Facebook, X, Reddit, and Instagram, where we're growing rapidly thanks to our social media team. You can also visit our website on www.breakthroughusa.com. We'd love to see you there.
Please note that this presentation should not be intended as legal advice for your specific situation. If you, a friend, or a family member would like a free consultation, you can visit our website at www.breakthroughusa.com and schedule an appointment. We'd love to hear from you and help you if we can. We'd also like to point out that this presentation was created using AI hosts. Okay, let's dive in.
So, I want you to imagine a scenario. You're sitting at your kitchen table.
Okay, setting the scene.
Right. Your bags are packed for a flight tomorrow. You've got your coffee. You've got your passport right there. You log in to submit your routine ESTA update.
Which is something, most frequent travelers have done a dozen times before, right? Without a second thought.
Exactly. You just hit submit, and you fully expect that familiar green approval screen. But instead, the screen flashes red. Travel not authorized.
Oh, wow. That's panic-inducing.
It really is, because there's no drop-down menu explaining it, no, customer service helpline you can just call.
Right, no explanation whatsoever, just a digitally locked door.
And that, honestly, is a visceral nightmare for anyone who travels regularly.
Yeah, our legal team's research paints this exact scenario as one of the most common and, frankly, terrifying moments a traveler can face. And it's primarily because of the silence, right?
The silence is the worst part.
Because when the system gives you absolutely zero context for rejection, human nature just sort of takes over. We panic.
We absolutely do.
We start guessing what went wrong, and then disastrously, we act on those panicked guesses.
Which is usually the fastest way to turn a minor, clerical issue into a permanent legal exile.
Exactly. So the entire focus of today's deep dive is answering the question nobody can seem to answer in that first terrifying minute. Why was it refused?
Right. Are you looking at a simple typo? Or a bureaucratic hurdle requiring a few months of paperwork.
Or a permanent barrier that, no amount of money or legal maneuvering will ever fix.
Right. And the research from attorney Chris Ingram and his team reveals that an ESTA can actually be refused for 8 distinct reasons.
8 reasons, okay.
Yeah, 8. And choosing the right path forward depends entirely on correctly diagnosing which of those 8 reasons trip you up.
Because guessing wrong can literally cost you years of your life. Not to mention thousands of dollars.
Oh, absolutely. But before we get into the actual countdown, let's establish a baseline here.
Good idea.
Because for many listeners, a sudden ESTA denial is their very first encounter with the actual machinery of the U.S. immigration system.
Right. They've never had to think about it before. So we need to define our terms clearly, starting with the ESTA itself.
Exactly. So ESTA stands for the Electronic System for Travel Authorization. It operates under the Visa Waiver program.
Which is basically the VIP pass, right?
Sort of, yeah. Historically, this program was created to facilitate easier travel for citizens of allied, low-risk countries.
Okay, so the U.S. government essentially waives its right to demand a formal visa.
Right. They offer a quick online permission slip instead. It's for tourism or business trips, usually up to 90 days.
Okay, so I always thought of the ESTA like the automated express lane at the airport or a nightclub. You tap your digital pass, the turnstile opens, and you walk through without ever speaking to a human being.
That's a really solid working model, yeah. It relies entirely on the databases talking to each other behind the scenes.
Right. Now, contrast that automated lane with a traditional visa.
Right. A visa is the manual, comprehensive method of requesting entry.
So it's not a quick online form?
Not at all. It involves extensive paperwork, deep background checks, and most crucially, an in-person interview at a U.S. embassy or consulate.
So if the ESTA is the express lane, the visa is the scenic route. You have to wait in line, and there's a human being checking your credentials at the end of it.
Exactly. And that human element is the defining difference here.
Because an automated system cannot understand nuance, right, or context.
Exactly. But a consular officer can. And that actually leads us to the third term we must clarify today.
Oh, right. The scary one.
Yes. A term which often sounds far more terrifying than it actually is, which is inadmissible.
Yeah, the word inadmissible just carries so much weight. It sounds like, I don't know, a judge slamming a gavel and declaring someone fundamentally unfit to enter society.
It does sound like that, yeah. People hear that word and immediately assume it's a permanent moral judgment against their character.
But the legal research stresses that we must strip the emotion away from that word.
Right. We really have to. In the realm of immigration law, inadmissible is a purely bureaucratic status.
So what does it actually mean, practically speaking?
It simply means that under the current reading of the statutes, you are not authorized to cross the border at this exact moment.
Okay. So it is not necessarily a reflection of your morality.
Not at all. And in a vast number of cases, it is entirely temporary.
That's a huge relief.
It is. In fact, much of the work our researchers do revolves around finding the legal mechanisms to allow inadmissible individuals to cross the border completely legally.
Wow. Okay, that distinction alone should lower the blood pressure of anyone listening right now. So we have our vocabulary down. But how do we structure a response when confronted with one of these 8 mysterious refusal reasons?
Well, the outline from our attorneys provides a brilliant triage framework for this.
Right, they break the chaos down into 3 distinct buckets.
Exactly. So when you're sitting there staring at that travel not authorized screen, you must mentally categorize the potential issue.
Okay, so you have to ask yourself, is this a mistake, a status issue, or a history issue?
Right. Those are your 3 buckets.
I assume a mistake is the lowest stakes category.
Yes.
Like typos, outdated information.
Exactly.
The kind of things where the automated bouncer just couldn't read your ID properly.
Precisely. It's usually a quick fix. Now, a status issue is a bit more complex.
How so?
It involves things like your nationality, your recent travel footprint, or maybe a prior bureaucratic decision on your file.
So a status issue generally means you are permanently kicked out of the express lane.
Yes, but you are perfectly welcome to use the regular visa route instead.
Okay, that makes sense. And then the history bucket. That sounds like the heavy end of the spectrum.
It really is. The history category involved actual behavioral choices.
Like overstaying a previous visit or criminal records.
Exactly. Or previous immigration violations. This is the bucket where you absolutely cannot proceed safely without professional legal analysis.
Okay, let's expand on that nightclub bouncer analogy for a second, because I think it perfectly captures the psychology of this automated system.
I agree. It's a great way to look at it.
An ESTA algorithm is like a bouncer with an earpiece who is strictly following a digital list. This bouncer has no brain, no empathy, and 0 interest in your life story.
Right. He doesn't care if you're having a bad day.
Exactly. He looks at your data, compares it to the database, and if a single parameter is out of alignment, he just crosses his arms and blocks the door.
That is exactly how the CBP databases function.
But being rejected by this bouncer doesn't mean you are banned from the nightclub forever.
Right.
It just means you have to come back during the day and have a sit-down meeting with the club manager, the visa officer, to explain the discrepancy.
Exactly. Because the computer algorithm can only parse data points. The consular officer has the authority to parse context.
Right. But before we count down the 8 specific reasons for that rejection, we have to address what our legal team calls the golden rule.
Oh, this is so important.
Yeah, it comes with giant red flashing lights in today's study. Because when people get rejected by the bouncer, their first instinct is often to try and sneak through a back window.
Which is the worst possible instinct.
And that usually manifests as lying, right?
Right. The urge to conceal information after a denial is literally the single most destructive impulse a traveler can have.
It's just human panic.
It is, but our research is unequivocal on this point. Whatever the original reason for your ESTA refusal, you must never attempt to lie your way around it.
So, never repeatedly submit the form hoping the algorithm just forgets your previous answer.
Right, it doesn't forget. And most importantly, never check no on a formal visa application when the factual, historical answer is yes.
Why are people so tempted to lie in this specific scenario, though? I imagine it's the sheer panic that one single yes will permanently ban them.
The fear is completely paralyzing, and it leads to a catastrophic miscalculation.
Because they convince themselves that admitting a flaw guarantees a refusal.
Exactly, so they try to bury it.
Yeah.
But under U.S. immigration law, lying on an ISTA or a visa application is formally classified as misrepresentation.
Misrepresentation. That sounds serious.
It is. You are willfully providing false facts to procure an immigration benefit.
So what are the actual mechanics of that penalty? If they catch you lying about a minor issue, do they just deny the application and tell you to try again?
No, the penalty is incredibly severe and often permanent.
Wow, permanent.
Yes. Misrepresentation under the Immigration and Nationality Act triggers an entirely separate, distinct ground of inadmissibility. It essentially acts as a lifetime ban.
A lifetime ban just for the lie.
Yes, and this ban is applied completely independently of whatever the original issue was.
Let's trace the logic there, because it's crucial for you listening at home to understand.
I was more than happy and satisfied with the services. The team was very prompt and immediate with their responses and guidance. I had seldom experienced such professional and efficient services provided. I would like to especially call out Hannah Nixon, who has been a wonderful partner to work with, and she has been so quick on our requirements that we at times had a hard time catching up with how quick she was working, though, the stages.
I might have an original problem that is incredibly minor, say, a misunderstanding about a previous tourist visa.
Right, something that attorney Chris Ingram's team could untangle in a matter of weeks.
But if I panic and lie about it on my next form, the minor issue is no longer my problem.
Exactly.
The lie is my problem, and the lie gets me banned for life.
Because the system views the cover-up as an attack on the integrity of the immigration process itself.
They take it personally.
They really do. The U.S. government operates on the principle that they must be able to trust the information you provide. If they determine you are willing to lie, to bypass the rules, you become an unmanageable risk.
It's like renting a car, accidentally putting a tiny scratch on the bumper, and instead of just paying the $50 fee, you panic and set the entire car on fire to hide the evidence.
That is a very drastic analogy, but legally it's accurate.
You've taken a minor, easily fixable inconvenience and escalated it into a massive felony. Honesty isn't just about ethics here, you know. It's a structural legal strategy.
A highly effective strategy, too, because it brings us to the ultimate myth our researchers want to dismantle today.
Which is?
Many travelers believe an ESTA denial is a permanent black mark that will ruin any future visa application. They assume this system permanently flags them as undesirable.
Well, I would absolutely assume that. If the computer says I'm a threat, why would the human officer disagree?
Because the consular officer knows exactly how blunt the ESTA algorithm is.
Oh, really?
Yes. The legal research confirms that an ESTA denial on its own does not doom a subsequent visa application.
Okay, so moving from the ESTA system to the formal visa process is not a punishment.
Not at all. It is simply a change in procedural lanes. Millions of legitimate, honest travelers go through the visa process every single year simply because their home countries aren't part of the waiver program.
But wait. When you apply for that formal visa, the DS-160 form explicitly asks if you've ever been denied an ESTA. Right, you have to disclose it.
You must disclose it. In fact, the officer will see the denial on their screen before you even sit down.
So if it's staring them right in the face, how does it not poison their opinion of you?
Because the officer is highly trained to investigate the underlying mechanism of the refusal, not the refusal itself.
Okay.
They are looking for the specific data point that tripped the algorithm. And this is where the human element becomes your greatest asset.
Because you can finally talk to someone.
Exactly. The visa interview provides the platform you were denied by the online system. You get to explain the context, provide the supporting documentation, and tell your story to a human being.
A human being who actually has the discretionary power to approve your entry.
Precisely.
Okay, the groundwork is laid, we have the triage framework, and we understand that honesty is absolutely non-negotiable.
Right.
Let's dive into the countdown of the 8 reasons your ESTA might be denied, starting in Category 1, the mistake bucket.
Okay, so reason number 8 is the simple clerical error. According to our legal team, this is the most common and easily resolved issue you can face.
So we are talking about pure, unintentional human error during the data entry phase.
Exactly.
I can picture this perfectly. You're filling out the form on your smartphone while half watching television. You flip your birth month and your birthday.
Or you accidentally type an O instead of a 0 in your passport number.
Right. You hit submit, and the bouncer immediately kicks you out.
And the mechanism behind this rejection really highlights how rigid these databases are. When you hit submit, the ECA system pings multiple international and domestic databases instantly.
What is it checking for?
It checks the biographical data you entered against the digital record embedded in your passport's microchip, which the airline also verifies.
So if my thumb slips and I say I was born on the 12th instead of the 21st, the computer doesn't think, oh, they probably just made a typo.
No, it thinks, This person is attempting to travel on a passport that does not belong to them.
Wow. It sees a discrepancy, and its only programmed response is refusal.
Exactly. It possesses zero common sense or deductive reasoning.
So what is the actual remedy here? If I realize I just typed my name wrong, do I need to call our attorneys and start drafting a legal defense?
Not at all. This is the rare scenario where no legal intervention is required.
Oh, good.
You basically just wait 24 hours to ensure the system resets, carefully review your passport, and submit a brand new application with the correct data.
And that's it?
Yep. The new application overwrites the old, mismatched one, and the barrier vanishes.
Our researchers did include one major caveat here, though.
They did.
You have to be absolutely 100% certain that your denial was actually caused by a typo and not by one of the heavier reasons we're about to discuss.
This is critical. If you were denied because of a hidden travel history issue and you blindly assume it was a typo,
And you just keep hitting resubmit.
right, resubmitting the form repeatedly will just result in a cascade of instantaneous denials.
Which creates a paper trail.
It begins to create a very messy digital trail that looks like desperate, erratic behavior to an investigating officer later on.
You don't want to look like you're trying to force the lock.
Definitely not.
So, moving on to reason number 7. We're still in the mistake bucket, but this involves a failure to update your reality.
Right. Let's assume you acquired dual citizenship since your last trip.
Okay.
Or perhaps you recently married and legally changed your surname. Or simply, your old passport expired and your government issued you a new one with a new alphanumeric number.
The trap here is psychological, I think. If I got an ESTA approved 2 years ago, I naturally assume the U.S. government gave me, the human being, permission to travel.
Right, you think you're approved.
I'm still me, so I assume I'm still good to go.
But that assumption fundamentally misunderstands how border security operates. The U.S. government did not give you abstract permission.
What did they give permission to then?
They gave highly specific authorization to the exact travel document, the physical passport, and its associated data string that you presented at the time of application.
Oh, I see.
An ESTA is a living, strictly tethered record.
So if I show up at the airport with my brand new passport, the airline's advanced passenger information system pings the CBP database.
Right.
It sees that my new passport number has no active ESTA attached to it, and the airline legally cannot print my boarding pass.
Exactly. Because the airline faces massive fines if they transport an unauthorized individual, so they will absolutely deny you boarding on the spot.
That would ruin a vacation real fast.
It happens all the time. Furthermore, if you legally change your name but try to travel on an ESTA tied to your old name, the system will flag the mismatch and quietly cancel your authorization.
Quietly, without sending an alert.
Often without any alert, yes.
The remedy for this seems just as straightforward as fixing a typo, though.
It is. You must proactively bring your digital record into alignment with your physical reality. Just apply for a new ESTA using your new passport number or your new legal name. Once the database recognizes that the new information is internally consistent, the authorization is generally granted.
Okay, we love the mistake bucket. It's clean, it's fast, and it doesn't require a lawyer.
Enjoy it while it lasts.
Right, because we are now leaving the shallow end of the pool and crossing to Category 2. The status shifts.
Yes, this is where it gets complicated.
This is where innocent people get caught in the gears of geopolitics. Let's look at reason number 6, nationality or travel history.
This specific reason generates immense shock and frustration among travelers.
I can imagine.
Because it targets individuals with absolutely flawless behavioral records. Under current U.S. law, specifically legislation expanded around 2015, if you hold dual citizenship with a country designated as high risk by the U.S. government.
Or if you have merely set foot in one of those countries within a certain time frame.
Exactly. You are legally stripped of your visa waiver privileges.
It's just like that. Let's unpack the case study provided by our legal team, because it really highlights how unfair this feels on a human level.
The Tomas case.
Yes. They presented a traveler named Tomas. Now, Tomas is a highly successful executive. He's never committed a crime, never overstayed a visa, and has visited the U.S. dozens of times without incident.
A perfect traveler profile.
Right. But 18 months ago, his company sent him to a 3-day academic trade conference in a nation that recently landed on the restricted list.
Okay.
He goes, presents his paper, and flies home. A year later, he applies for an ESTA to take his children on vacation to Florida, and the screen instantly denies him.
Instantly.
He's being treated exactly like someone who just committed a felony.
And from Tomas's perspective, it feels like a profound accusation. It feels as though the U.S. government is labeling him a security threat or a criminal sympathizer simply for doing his job.
Why wouldn't it feel that way? He's suddenly kicked out of the VIP line and told he's not trusted anymore.
It feels awful. But if we examine the legislative history and the intelligence mechanisms driving this policy, we see it isn't a personal accusation at all.
What is it then?
The U.S. government is not declaring Tomas a threat. They are acknowledging a gap in their own intelligence network.
Huh.
The countries on that restricted list typically lack the robust information sharing agreements the U.S. relies upon for automated security vetting.
Okay, so the algorithm basically can't see what Tomas was actually doing during those 3 days, so it just defaults to caution.
Precisely. The system is executing a blunt legislative mandate. The law basically states that exposure to a data-blind region automatically disqualifies you from automated entry.
It's just a blind spot for them.
Right. The government requires a deeper look, which an algorithm cannot provide.
And this is where our triage framework becomes a lifeline for Tomas. He needs to recognize that he is in the status bucket, not the history bucket.
Exactly.
He doesn't need to mount a massive legal defense of his character. He just needs to change lanes.
His remedy is purely procedural. He must apply for a standard B1, B2 visitor visa. He will go to the embassy, present his itinerary from the trade conference, and answer a few routine questions. In the vast majority of these cases, once the consular officer verifies the benign nature of the travel, the visa is granted.
So it is an administrative inconvenience, not a permanent stain on his record.
Exactly.
Let's move to reason number 5, past visa refusal. This one seems like the ESTA system is just holding a grudge.
Well, the databases are deeply integrated and they have perfect memory.
Wow.
If you have ever applied for any type of U.S. visa, student, tourist work and been formally refused by a consular officer, you are permanently ineligible for the ESTA shortcut.
Why does a past refusal act like a permanent lock on the automated door, though? Say I was denied a student visa 10 years ago because I couldn't prove I had enough money in my bank account.
Okay.
But I'm a successful professional now. Why can't the algorithm see that I've changed?
Because the algorithm is binary. It only registers the event. Prior refusal equals true.
That's all it sees.
That's it. It is entirely incapable of evaluating the context of that refusal or assessing your personal growth over the last decade. A past refusal indicates that a U.S. official previously identified a deficiency in your qualifications.
Okay, so the computer defers to the human from 10 years ago.
Exactly. The automated system is not authorized to override a human officer's prior negative adjudication.
So I can't just try my luck online and hope the system doesn't notice?
The application explicitly demands to know if you've ever been denied a visa. If you tell the truth, as you must, you trigger an automatic denial.
And if you lie and say no...
We are back to the catastrophic consequences of misrepresentation we discussed earlier, the lifetime ban.
Right. So the remedy here is confronting the past. You have to go back through the formal visa process and prove to a new human officer that the circumstances which caused your refusal 10 years ago have materially changed.
Yes, you must resolve the root cause. If you're denied for lack of funds previously, you must now present compelling financial documentation.
Right.
You must demonstrate that the previous deficiency no longer exists.
Which flows directly into reason number 4, prior ESTA refusal or cancellation. And this one feels like the most modern anxiety on our list.
It definitely reflects the current reality of continuous vetting.
Continuous vetting.
Yeah. In the early days of the program, an approval was static. You got approved and you were good for 2 years.
Right.
Now, U.S. Customs and Border Protection constantly runs approved ESTA profiles against updated global watch lists, criminal databases, and intelligence feeds.
Our legal team notes that people are having their authorizations canceled completely out of the blue, sometimes while they are literally in a taxi heading to the airport.
It happens. Continuous vetting means a new piece of data, perhaps a namesake being flagged in a foreign database, or a sudden change in a country's risk profile, can trigger an immediate automated revocation of your travel privileges.
And this happens without a single word of warning.
Without a single word.
The natural human reaction to a sudden cancellation like that is to assume the website glitched. You hit refresh and submit a new application immediately.
Which is, again, the worst tactical move you can make. The door has been locked by a systemic trigger. Submitting 5 identical applications in an hour won't pry the door open.
It just makes it worse.
It simply flags your profile as erratic and potentially desperate.
It makes you look like you're trying to brute force your way past security.
Exactly. The remedy is to stop fighting the algorithm. If your ESTA is canceled or refused, immediately pivot to the formal visa process.
Because the online system refuses to offer an explanation, but the consular officer at the embassy is literally required to engage with you.
Exactly. Transitioning to the human process moves you out of a digital dead end and onto a navigable legal pathway.
Okay, we are now crossing the most significant threshold in our countdown. We are leaving the status bucket and entering Category 3, the history hurdles.
This is the deep end.
Yeah, we're no longer talking about typos or intelligence blind spots. We are talking about behavioral choices in breaking the rules. Let's tackle reason number 3, overstays.
Right. So the technical term in immigration law is unlawful presence, and it carries immense weight.
What exactly does it signify?
It signifies that you previously entered the United States and remained within its borders longer than your authorized period of admission.
Okay.
Alternatively, it can mean you violated the terms of your stay, for instance, by working under the table on a tourist visa, or that you were formally subjected to deportation proceedings.
Our legal research emphasizes that the penalties for unlawful presence are not subjective. A judge isn't looking at your case and deciding how angry they are. It's a strict mathematical calculation.
It is entirely mechanical, dictated by Section 212 and U9 of the Immigration and Nationality Act. The system essentially relies on your arrival and departure records to calculate your exact footprint in the country.
So how does the map actually work? What triggers a ban?
Well, if you overstay your permitted departure date by more than 180 days, which is roughly 6 months, and then you voluntarily depart the United States, you instantly trigger a statutory 3-year ban on returning.
Wow. So if I stay 6 months and 1 day past my welcome, I'm locked out for 3 whole years. What if I stay longer?
If you accrue a full year or more of unlawful presence and then depart, you trigger a severe 10-year ban.
10 years.
10 years. While those respective clocks are ticking, you are legally barred from entering the United States.
Okay, but if I have an emergency or I really want to attend a family wedding during that time, can I just hire attorney Chris Ingram's team to negotiate that ban down?
Obtaining a waiver for an active unlawful presence ban solely for the purpose of a tourist visit is extraordinarily difficult.
Really?
Yes, bordering on impossible in many routine scenarios. The bans are designed to be highly punitive deterrents.
But the research highlights a fascinating, almost optimistic reality built into this harsh math. The bans aren't permanent.
No, and this is where understanding the mechanical nature of the law is actually empowering. These bans have a firm statutory expiration date.
Like a countdown timer.
Exactly. The clock begins ticking the exact moment you depart U.S. soil. Once those 3 consecutive years or those 10 consecutive years have passed while you reside outside the country, the ban simply expires. It switches off.
That is incredible. I think the vast majority of people assume a 10-year ban is basically a permanent black mark that will haunt them forever. They don't realize it's a literal countdown timer.
Many travelers give up entirely, assuming they are exiled for life. Or they spend immense resources trying to fight a ban that is already counting down on its own.
Which is why having the right counsel is key.
This is exactly why a consultation with our attorneys is invaluable. A legal professional will meticulously calculate that timeline, cross-referencing your exit stamps with the exact statutory requirements.
And what might they find?
They may discover that your ban actually expired 2 years ago, and you are completely free to apply for a visa.
Oh, wow. You still can't use the ISTA, obviously, because of the history,
Yeah.
but you are clear to apply for a standard visa without needing a complex legal waiver.
Exactly.
Okay, we are near the top of the list. Reason number 2 is perhaps the most insidious, because it doesn't involve breaking any rules, lying, or committing a crime. It trips up completely innocent people every single day.
Yes.
It's the psychological test of future intent.
We are discussing Section 214B of the Immigration and Nationality Act. This is the hidden assumption that governs the entire U.S. visitor visa system. And globally, it is the most common reason for a visa refusal.
Explain the legal burden of Section 214B. What is the U.S. government legally mandated to think about me when I walk up to that interview window?
By law, the consular officer is required to presume that every single applicant for a temporary visitor visa actually possesses immigrant intent.
Immigrant intent, meaning?
They must begin the interview with the legal assumption that you are secretly planning to abandon your home country, move to the United States permanently, and never leave.
That is the literal definition of guilty until proven innocent applied to a vacation.
It feels incredibly adversarial to a first-time applicant, but it is the structural foundation of the law. The burden of proof rests entirely on your shoulders.
So what do I have to do?
You must proactively convince the officer, usually in less than 3 minutes, that your life in your home country is so compelling and deeply rooted that you couldn't possibly abandon it.
I use the first date analogy to explain this to people. Imagine you go on a first date. You sit down for coffee, and within the first 5 minutes, your date starts talking about getting married, buying a house together, and naming your future children.
You would be terrified.
You'd fake an emergency and run for the door. The U.S. immigration system is on a first date with you. If you show up and start talking about vague, open-ended plans, or how much you love America and want to see where things lead, you are terrifying the consular officer.
That analogy perfectly encapsulates the psychology of the interview.
You have to prove you have your own independent, fulfilling life back home, and that you are just stopping by for a quick, strictly defined visit.
Right. A 214B refusal is almost always triggered by innocent conversational phrasing that reveals a lack of deep ties.
Like what?
An applicant might casually say, I just want to explore some opportunities, or my partner lives in New York and I'd love to spend a few months experiencing the city.
To the applicant, that sounds romantic and adventurous.
To the highly trained officer listening for intent, it sounds like an individual with zero constraints who is highly likely to overstay their visa and merge into the U.S. economy.
So what is the remedy if you fail this psychological test? You can't appeal it to a judge, right?
There is no formal appeal process for a 214B refusal, and there is no legal waiver you can file.
Oh.
The only path forward is to reapply. But our legal team stresses that you should only reapply when you have accumulated overwhelming, concrete evidence of your ties to your home country.
What does that evidence actually look like in the real world, though? Is a bank statement enough?
A bank statement is easily manipulated. Officers are looking for structural roots.
Structural roots? Like what?
They want to see a letter from a long-term employer explicitly stating that you are expected back at your desk on a specific Tuesday. They want to see a mortgage, a long-term lease, or enrollment in a rigorous university program.
Okay, so heavy obligations.
Right. They want to see dependent family members who physically require your presence. And crucially, they want to see a tight, logical travel itinerary. A 2-week holiday with a return ticket, not an open-ended exploration.
You basically have to prove that walking away from your life would be painful and difficult.
Exactly.
And that brings us to the summit, the final boss of our countdown. Reason number 1 for an ISTA denial: criminal records.
Yes. This is the area of immigration law that requires the most delicate handling, the deepest legal expertise, and a willingness to confront uncompromising realities.
Let's establish a baseline. What kind of crimes trigger an automatic inadmissibility flag?
The law specifically targets crimes involving moral turpitude, which is a complex legal term that generally encompasses acts of fraud, dishonesty, or malicious intent, as well as multiple criminal convictions and anything related to controlled substances.
But before we get into the details of the crimes, we have to bust a massive myth regarding foreign legal systems. A lot of countries have rehabilitation laws, right? Spent conviction laws, where a minor offense is eventually wiped from your public record.
Yes. In the UK, for example, a minor offense might be considered spent after a few years of good behavior. You are legally allowed to tell an employer there that you have no criminal record.
Right. And the myth is that these foreign laws apply to U.S. immigration.
Right.
Why wouldn't they? If my home country forgives me, why does America care?
Because U.S. immigration law operates entirely independently of foreign rehabilitation schemes.
I had an exceptional experience working with Rodolfo and the team at the law offices of Chris M. Ingram. From the very beginning, they were clear, professional, and supportive throughout my EB-1A journey. Rodolfo was always quick to respond to questions, provided detailed guidance at every stage, and ensured my case was thoroughly prepared. Thanks to their expertise and dedication, my EB-1AI 140 petition was approved smoothly. I truly appreciated their attention to detail and commitment to helping me succeed. I highly recommend Rodolfo and the entire team to anyone navigating the complex U.S. immigration process. They're the best in the field.
To the U.S. government, a conviction is an immutable historical fact.
It never goes away.
Never. It does not matter if your home country expunged it, pardoned it, or considers it spent. You are legally obligated to declare a minor arrest from 30 years ago even if no public record of it exists in your home country anymore.
That feels incredibly harsh for someone who made a dumb mistake in college and has been a model citizen ever since.
It is harsh. But this is the crucial pivot point of our discussion today. A denial based on a historical criminal record does not automatically equate to a lifetime ban from visiting the United States.
It doesn't.
No. It simply means the automated express lane is permanently closed and you must utilize a specific legal tool to open the manual door.
So what is that tool? How do you ask for forgiveness?
The remedy is a 212 D3 non-immigrant waiver.
Okay.
This is a formal discretionary grant of forgiveness from the U.S. government that temporarily sets aside your inadmissibility, allowing you to enter the country for a specific visit.
How does the process actually work? Do I just write a really apologetic letter?
The process is deeply integrated into your visa application. You disclose the record fully on your forms. You attend the embassy interview, bringing all official court documents.
Right.
The consular officer evaluates your case and basically acts as the gatekeeper. If they believe you are rehabilitated, they submit a formal recommendation to the Admissibility Review Office in Washington, D.C., asking them to grant the waiver.
How does the officer decide, though? Are they just relying on a gut feeling about whether you're a good person?
No, the adjudication is governed by decades of legal precedent, primarily stemming from a landmark case known as the Matter of Franca.
The Matter of Franca.
Yes. The officer must balance 3 specific criteria.
What are they?
First, the risk of harm to U.S. society if you are admitted. Second, the seriousness of your prior criminal violation and how much time has passed since it occurred. And third, the nature of your reasons for wishing to enter the United States.
I want to focus on that third criterion, the reason for entering. Do I need to invent a dramatic excuse? Like, I have to attend a vital corporate merger, or I need specialized medical treatment.
That is a very common misconception. The Matter of Franca precedent explicitly states that the reason for travel does not need to be compelling or extraordinary.
Yeah.
Wanting to take your children to Disney World, attending a friend's wedding, or simply going on a sightseeing holiday are all considered perfectly valid reasons to request a waiver.
So the system is essentially acknowledging that human beings are capable of change.
Exactly. It is a formal recognition that a mistake made in 1995 does not inherently define a person's risk profile in 2026. The government is engaging in managed risk assessment, not demanding historical perfection.
But our legal research points out that before you even start drafting a waiver request, you might be protected by an exception. There are scenarios where a crime doesn't actually make you inadmissible.
And this is why an initial analysis by a team like attorney Chris Ingram's is so vital. There are 2 major statutory exceptions to look out for.
Okay, what's the first one?
The first is the petty offense exception. This can protect you if you have only one single conviction for a minor crime involving moral turpitude.
How is petty defined mathematically?
The test is very strict. The maximum possible penalty for the crime you committed could not have exceeded 1 year of imprisonment, and the actual sentence you were handed by the judge could not have exceeded 6 months.
Okay, let's use the fictional case study our researchers provided. Sophia. She's a prominent management consultant today, but 20 years ago, during a tough period at university, she was convicted of a minor shoplifting charge.
Right.
She paid a small fine, did some community service, and has had a spotless record ever since.
Sophia's scenario is textbook. Shoplifting is a crime of moral turpitude, so she is flagged by the system and her ESTA is denied.
What?
But because it was a single isolated incident and the penalty was far below the statutory threshold, a skilled attorney would argue that she qualifies for the petty offense exception. She isn't actually inadmissible.
So she just gets her visa.
She still has to go to the embassy and prove it, but she won't need the complex 212D waiver.
And the second exception?
The juvenile exception. This applies if you committed a single offense while under the age of 18 and a minimum of 5 years has passed since the conviction or your release from confinement. It is the legal system's way of acknowledging that minors lack full culpability.
We've covered the hopeful paths, the waivers, and the exceptions, but our deep dive requires absolute honesty. And the research highlights one specific area where the law offers almost zero grace: drugs.
Yes, we must deliver the hard truth here. U.S. immigration law treats offenses involving controlled substances with unparalleled severity.
How much nuance is there? If I got caught with a single marijuana joint at a music festival 20 years ago, is that viewed the same as running a cartel distribution network?
There is a vital distinction, but the baseline remains incredibly rigid. A single historical conviction for simple possession of a small amount of marijuana, specifically under 30 grams, might, with highly skilled legal representation, be workable through the waiver process.
But what if it's beyond simple possession?
If the record involves trafficking, distribution, or intent to supply, even if it was a tiny amount shared among friends decades ago, you hit a near insurmountable legal wall.
Wow.
Section 212A2C of the Act treats drug trafficking as a permanent, absolute barrier.
A permanent closed door. No waivers, no exceptions, no amount of time passed changes it.
No amount of character references, charitable work, or time elapsed will alter the black and white text of that statute for a non-immigrant visitor. This is the moment where the integrity of a legal team, like our attorneys, is truly tested.
Because they have to be willing to tell a client no.
Precisely. The immigration landscape is full of unscrupulous operators who will gladly take thousands of dollars from a desperate client to file a waiver application that they know possesses zero statistical chance of success. A true professional will examine a trafficking record, look you in the eye, and explain that the fight is unwinnable. Providing the honest truth and preventing a client from pouring their financial and emotional resources into a black hole is often the most valuable service a lawyer can provide.
That is heavy, but it is deeply necessary. We've navigated the 8 reasons. We've gone from typos to drug laws. Now let's move into Section 8, the aftermath. We need to give the listener a concrete roadmap. What actually happens when you apply for that waiver and you're waiting for an answer?
You must prepare yourself psychologically for a bureaucratic phase known as administrative processing.
I've heard horror stories about administrative processing. It sounds like a digital purgatory where applications just disappear.
It can certainly feel like purgatory. When you attend your embassy interview and require a waiver, the consular officer rarely gives you a final answer on the spot.
What do they give you?
Instead, they will hand you a piece of paper, usually a 221G form, informing you that your case is undergoing further administrative processing.
Which instantly triggers a panic attack. People assume they've been rejected politely.
Exactly. They assume failure. But our researchers want to reframe this entirely. Administrative processing in a waiver case is not a rejection. It is the standard operating procedure.
Okay, why?
The consular officer does not have the final authority to grant a 212D waiver. If they support your application, they must bundle your file and transmit it securely to the Admissibility Review Office in Washington, D.C.
So you are literally just waiting in a digital queue for a specialized supervisor to review the officer's recommendation?
Yes. The ARO is a specialized unit that handles waivers globally. Because of the sheer volume of applications, the wait can stretch for weeks or even several months.
That wait must be agonizing.
The silence is agonizing, but understanding the mechanics of the wait changes your psychology. You shift from thinking, I have been denied, to understanding, my case is moving through the required security checkpoints.
Knowing the plumbing of the system makes the wait tolerable. Now, let's bust a massive myth regarding the waiver itself. If I go through all this trouble, wait months, and finally get my 212 waiver approved so I can go on vacation, doesn't that mean I'm officially forgiven? Can I use that forgiveness to apply for a green card later?
Absolutely not, and assuming otherwise is a catastrophic error. The 212 waiver is exclusively for temporary non-immigrant visas. It is a temporary pass.
It doesn't transfer over.
No. The legal threshold to immigrate permanently and obtain a green card is vastly higher, and the waiver mechanisms for permanent residency are entirely different and far more restrictive. Forgiveness for a 2-week holiday does not translate into forgiveness for permanent residency.
Okay, let's pivot to some unexpectedly good news because this isn't all grim. Our legal team points out that losing your ESTA privileges actually comes with a massive hidden perk for the frequent traveler.
It does. It feels like a demotion, but practically it functions as an upgrade.
How so?
An ESTA authorization is inherently limited. It only allows you to remain in the United States for a maximum of 90 days per visit, and the authorization itself expires every 2 years.
What happens when you are forced into the visa route?
When you obtain a standard B1, B2 visitor visa, the border officer typically grants you an authorized stay of up to 6 months per visit.
Double the time on the ground.
Furthermore, the B1, B2 visa itself is often issued with a 10-year validity period, allowing for multiple entries over a decade without having to reapply. You endure the friction of the interview and the paperwork up front, but the resulting travel document is far more powerful and flexible than the express lane pass ever was.
I love that perspective. The penalty path actually leads to VIP status. All right, let's distill all of this into a concrete action plan. The listener is staring at the denied ESTA screen right now.
Yeah.
What are the literal step-by-step instructions from our legal team?
Step 1 is immediate containment. Do absolutely nothing on impulse.
Don't panic.
Right. Do not repeatedly submit new applications hoping the algorithm changes its mind. And under no circumstances should you fly to a U.S. port of entry hoping to charm a border guard into letting you in.
Bad idea.
Very bad. Arriving without proper authorization will likely result in expedited removal, which carries severe multi-year bans.
Do not fight the bouncer. Step 2.
Step 2. Diagnose the problem using the framework. Sit down calmly and categorize your reality. Are you dealing with a mistake, a status issue, or a history issue? Identifying the category defines your next legal move.
Identify the enemy. Step 3.
Step 3. Begin gathering official documentation immediately. If your issue involves any sort of criminal history, even a minor caution from decades ago, you will need the certified court dispositions.
Your memory isn't enough.
Memory is entirely insufficient. Retrieving archival court records from foreign jurisdictions takes significant time, so initiate that process today.
And finally, Step 4.
Step 4. If your diagnosis lands anywhere near the complex side of the spectrum, an overstay, a 214B intent refusal, or any criminal record secure a professional legal opinion before you spend a single dollar or submit a single form, navigating this landscape alone is dangerous.
As the saying goes, paying for the right first hour with an attorney who understands the machinery will save you years of suffering through the wrong legal strategy.
Absolutely true.
So I have to ask you, the listener, what stood out to you today? Was it the absolute shock that a single 3-day conference trip to the wrong country can nuke your ESTA without a word of warning? Or maybe it was learning the hidden mechanics of an overstay ban, the fact that those terrifying 3- and 10-year walls actually have built-in expiration dates. Or was it the realization that the Section 214B intent test can silently take down someone who has literally zero criminal history? Drop your thoughts in the comments wherever you're listening, because the detail that surprised you the most is very likely the exact piece of information the next panic traveler desperately needs to hear.
You know, when you step back and view this system in its entirety, it reveals a profound irony about modern border security. We engineered massive, interconnected systems like ESTA to make global travel frictionless and highly efficient.
Right.
But in our pursuit of that frictionless efficiency, we completely stripped away human grace, nuance, and individual context. The algorithm doesn't know you volunteer on weekends or that you were just a scared teenager 20 years ago. It just knows your data string doesn't perfectly align with its security parameters.
The reader only sees data. Only a human being can evaluate your story.
And that is exactly why, when the algorithm fails you, human interaction suddenly transforms into the ultimate premium commodity. That visa interview, which everyone dreads, is actually your greatest remaining asset. It is the moment you reclaim your narrative from the database. And if you want to understand how to shape that narrative even better, our team's other research piece, What is ESTA, is essential reading. It provides the map to the minefield before you ever take your first step.
Thank you so much for being with us today. We hope you gained a lot from this discussion. Please leave us a comment if you can. Additionally, you can support our channel by sharing it with your friends and family, helping us build this community together. Also, follow us on Spotify, YouTube, LinkedIn, Facebook, X, and Instagram, where we're growing rapidly thanks to our social media team. We would also like to thank attorney Chris Ingram and his dedicated team once again for researching and preparing this material for our presentation. See you next time on Let's Talk U.S. Immigration. Bye for now.